simply printing stuff from the internet and attaching it to a brief is not evidence.
Your Honor, I feel like being a candidate on the ballot is enough vested interest. I guess I wouldn't understand the position of having standing.
I hate to interrupt, but I'm sure Ms. Lake would agree with you as well. She was on the ballot for governor and she lost, but she was and that court found she didn't have standing.
I guess I don't understand the filings of Ms. Lake directly. As a pro se litigant, those are things that I don't have afforded to me. I don't have the money to have lawyers. I just know what's right and wrong by the Constitution.
'Cause I'm a drunk beaver. Yeah, I'm a drunk beaver. Chugging my beer while producing my stuff. Drunk Beaver Productions.
Alyssa Levitt versus Keesa Merriman, Thomas County case number 24CV25, announced appearances.
Your Honor, I'm Melissa Levitt, the petitioner.
Yeah, Ms. Levitt appears in person and pro se by Zoom.
Your Honor, Andrew Holder on behalf of defendant Merriman.
All right. Ms. Levitt, as you know, you have the right to be represented by counsel. You have filed this petition pro se. Is it still your intent to proceed today representing yourself?
Yes, Your Honor. Thank you.
All right. We're before the court on a motion to dismiss filed by the defendant, and the court granted the parties an opportunity for some subsequent briefing, and in the interim, Ms. Levitt filed some additional motions for emergency orders, particularly related to the primary, which has already occurred. And are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right. Ms. Levitt, you are the plaintiff, and it's your motions that have been filed to be dismissed. I have read Mr. Holder's brief on behalf of the county clerk, and I'm going to allow you to argue, although I would ask you not to read or repeat the arguments you've already made in writing as the court has reviewed those. Do you have anything additional you wish to offer in response to the briefs and motions filed by defense?
Not particularly, Your Honor. I just think that, I've supplied the court with as much as I could evidence-wise. I really didn't find anything additional that I could add to, go against what's already been mentioned by the defense in this matter.
Okay. Ms. Levitt, you understand there is absolutely no evidence before the court. Printings and attachings to brief are not evidence. Evidence requires that items be submitted under oath, that there be testimony, that there be an opportunity for that information to be challenged by the other side. Simply printing stuff from the internet and attaching it to a brief is not evidence. Do you understand that?
Okay, sure. Thank you, Your Honor.
You're welcome. And so while there were, I think one of the petition or one of the motions was 88 pages, most of it was materials printed from the internet, which are not verified, certified, or in any way under oath, and therefore cannot be considered by the court as evidence in this case. You understand?
Okay, I do now. I'm sorry. I apologize.
That's okay. One of the things I wanted to ask you is I've read the original petition, which this whole case is generated from for mandamus, and I'm trying to figure out succinctly the particular challenge you've got. Let me ask you, if I might. It appears that the main challenge, as I've gleaned from your petition for mandamus, is that you were asserting the machines used by the county clerk may have the ability to be connected to the internet. Is that correct?
That is correct, Your Honor.
All right. And I believe these are machines that you acknowledge have been qualified or certified by the Kansas Secretary of State to be used in elections, correct?
That is also correct. Yes.
Right. And when I looked at your petition page, they're not numbered, but the 5th page, the bottom paragraph number 4 on that page says to the effect, it requires a thorough inspection from someone capable of identifying those hardware components, as some can be as tiny as the tip of a pencil. And you're talking about needing these machines to be examined to determine whether, in fact, they can be connected to the internet, correct?
Correct.
So you don't have any evidence that these machines can, in fact, be connected to the internet?
Your Honor, I would draw your attention to the word capable. They do have the capability of that. That was put forth with the actual Dominion patent. That was my intention, and I understand that the court may not view that as evidence, but it isn't just anything I've drawn up. The capabilities that are in computers today, it's very hard to even find any computer that you don't just plug in and is capable of some kind of cellular, any of the things listed in our statutes. And so as much as I have tried to verify, I'm being withheld from that, even to the extent that the Secretary of State's office is deleting those certifications or examinations if they even occurred. So at this point, I don't really know how it can be determined if that is an assumption. I can only give what is factual, and that they are built to network, in fact.
Well, that, as you point out, and you use that very word, best we can do is speculate.
Right. And so that's the point to that is that there is no evidence from the state stance as far as the Secretary of State would be concerned either. So I don't know how we get that when we're denied that as people, who are trying to find out.
Okay. And you may have a very good point there, but you see, that's not what a court of law or an action for mandamus is for. An action for mandamus and a court of law is not an investigatory body. That would be something you would address with the legislature or with the executive branch, which would be the Secretary of State, not through a court of law. Mandamus is a very specific action which mandates that an elected official do something. This is an action, as I've read it, and you've summarized or agreed with my summary, where you're saying, I want somebody to investigate these machines. That's not what you do in a mandamus action.
Yeah, Your Honor, and I understand that. And I have done my very due diligence in doing that myself. Having expert attachments, even though the court doesn't view them as testimony, these are very specific documents that are provided by the federal EAC of the components. The components are there. You can go look up these computer documents. And even though I don't have something in an evidentiary standing with the court at this time, they are factual. And I would be more than glad to have the opportunity to bring it as evidence, Your Honor, because it would be under perjury.
Correct. And that's the best evidence you can have is evidence under oath, because perjury applies, and we don't have that here. You mentioned also in your petition citing, appropriate law in support of your position. That would be paragraph 3.5. Petitioner cites relevant case law, and you cite the Schneider versus City of Kansas City case. You would have to admit that the defense has cited a number of cases that have been brought around the country. In fact, one that you were involved in federal court, which deal with the issues of standing and some of the other things that are relevant to this case that you have not answered in a reply brief. The O'Rourke versus Dominion voting systems, the 10th Circuit case, dealing with almost identically what you brought here, where the 10th Circuit Court of Appeals, that's one step below the United States Supreme Court, found that the individuals had no standing to assert claims similar to those that you have brought in this action. Another name that's quite familiar is in the case of Lake versus Hobbs, which is an Arizona case. Carrie Lake, who lost an election for governor, challenged the election, made all sorts of allegations, was unsuccessful through a number of lawsuits, now is running for United States Senate, brought almost identically the same issues you did. And the courts in Arizona found that she had no standing. She was asserting a general right and not one that the courts are in a position to interfere in. So knowing that you cited relevant case law, all of the relevant case law cited by the defense that you did not reply to, it's all contrary to your position.
Your Honor, I feel like being a candidate on the ballot is enough vested interest. I guess I wouldn't understand the position of not having standing.
I hate to interrupt, but I'm sure Ms. Lake would agree with you as well. She was on the ballot for governor and she lost. Now, of course, she's on for the Senate. But she was and that court found she didn't have standing.
Your Honor, I guess I don't understand the filings of Miss Lake directly. As a pro se litigant, those are things that I don't have afforded to me. I don't have the money to have lawyers. I just know what's right and wrong by the Constitution. Our state constitution says that our laws are to be followed directly under the elections procedure, and that is not taking place. So that's why I wrote my writ.
Good. Well, and finally, while not identical, no two lawsuits are identical, but similar was a case that you participated in as a party, Roberts versus Caskey, in federal district court, 22 CV 2366. What did the judge rule there?
The judge, we were not in proper jurisdiction, Your Honor.
Okay. Again, a standing issue.
Yes. And that's just kind of the thing. As a citizen of the United States and not having legal support, we do our best, and I have certainly done my best to be due diligent, to honor the court and the laws of this country. So, I don't really find that those particular cases are relevant to this matter. That's why I didn't respond to those. They're very different. This is directly related to my candidacy in my own county and the statutes that are written by our legislature. All
right. Well, knowing that I've read the briefs and the law as prescribed, is there anything more that you wish to add? I'm going to ask Mr. Holder to weigh in if there's anything he wants to supplement as part of his argument. Anything more that you want to add at this time?
I just pray the court doesn't dismiss this case, Your Honor. I think it's imperative we stand by our state constitution.
Okay. Mr. Holder, anything additional you wish to add regarding your positions with either the petition for writ of mandamus or the motions that the plaintiff filed for emergency injunctions?
Your Honor, at this point, and particularly given the argument, I think that the court has the briefs and has read them. I don't have anything to add that hasn't already been briefed, so I'd stand on my brief, Your Honor.
Okay. Well, the court's going to adopt the legal analysis as provided by the defendant and find that the plaintiff in this case has no standing regarding the writ for mandamus. In addition, the court's going to find that the statutes are not in violation. The machines that are being challenged have been qualified by the chief election officer for the state of Kansas, who is the Secretary of State, that they're being conducted properly, that they're not in violation of either the Kansas Constitution or the statutes as referenced. So not only on the standing issue, but should the standing be found by an appellate court, if this goes up on appeal, that she did have standing, court's going to find that there is no injury, that there's no proof of any injury, that there's no evidence that the court could rely upon to allow this case to go forward. And so on all of those, the court will adopt the legal authority cited by defense in support of its decision to dismiss the petition of writ of mandamus and to deny any request for any emergency or temporary relief. Mr. Holder, if you'll prepare an appropriate journal entry. Ms. Levitt, I am required to advise you that as a result of the court's decision, you do have the right to appeal. The court cannot appoint you a lawyer nor assist you in any way in perfecting that appeal, but you must file that on your own if you wish to appeal the decision of the court. Do you understand that?
Yes, Your Honor. Thank you.
Okay. Mr. Holder, anything else?
Your Honor, just so that there's an abundance of clarity on the issue, given that Ms. Levitt is not represented, the court has asked me to prepare a journal entry memorializing the court's ruling today, which I am then required to provide a draft copy of to Ms. Levitt so that she can review and make sure. I just want to make sure that we get clear with Your Honor that the point of providing that is not to debate whether Ms. Levitt agrees with the ruling or not. It's simply to memorialize that I've accurately recounted what Your Honor has ruled.
That's a good point. And with Ms. Levitt not being represented by counsel, Ms. Levitt, Mr. Holder is going to prepare a journal entry basically that outlines to the extent he can the ruling that I made. You may not agree with the ruling, but all he is trying to do is memorialize in a written instrument what I ruled. And he's going to send you a copy of that. You may say, I disagree with the judge. I don't think he's right, but that's not the form. That's what you do on appeal. When you get a copy of that, I think what you'll do is submit this Rule 170, Mr. Holder. You'll have, after you receive it, you got 10 days to file a written objection that he did not encapsulate correctly in the document what I ruled today, not that you agree with the ruling. Do you understand the difference?
Sure.
Do you have any, so in other words, don't file a written objection saying, I disagree with the judge. Your objection would have to be that Mr. Holder didn't memorialize what I ruled correctly. That would be the substance of an objection. Do you understand?
Yes, thank you.
Okay. A lot of pro se litigants think that they're supposed to object because they disagree with the judge, and it's not. You're supposed to object if you think Mr. Holder got what I ruled incorrectly. And what I ruled is you don't have standing, but that even if a court on appeal would find that you did have standing, that there is no injury or justiciable controversy that the court can rule upon based on the petition for writ of mandamus. And so he'll set that out in the ruling.
Okay.
You may have a forum for your objection, but it is not in a writ of action for mandamus. Your forum would be preferably at the legislative level or again with the executive branch. And at this point in time, not based on the mandamus petition that was filed. All right. With that, anything further for the record today?
No, Your Honor.
Mr. Holder?
For the defendant, Your Honor.
All right. Thank you. And we will be adjourned.
Thank you.
Thank you.
Good afternoon. This is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for August 6, 2024. Again, all matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we're streaming all matters live via YouTube. I'll go ahead and call the next two cases, calling cause numbers 2024 0D00222 and 2023 0D04034. Each case styled the state of Texas versus Steve Jonathan Ugarte. May I have announcements, please?
Ada Warner for the state of Texas, present ready, Your Honor.
Judge Daniel Avalar for Steve Ugarte, Your Honor. Good afternoon, Judge.
Good afternoon. And for purposes, oh no. I don't have waivers of in-person, please.
Yes, ma'am.
So I cannot,
And there's case law saying we can't do it on orally, huh?
we gotta do it in writing.
Gotta do it in writing.
And I can't even say I want to bring you in person now because we've got our jury panel for Thursday. So we're picking a jury on Thursday. And we're in trial on Tuesday, so I don't want to set you for Tuesday. All right, so. Mr. Nunez,
Yes, ma'am.
no, it's not gonna work either.
What can we do, Judge? Why don't we bond him out?
Your Honor, if we can do it the week after, that'll allow us to change the plea papers and make sure everything is correct.
we'll go ahead for now and set him for Tuesday at 9 a.m. Okay.
Yes.
All righty. We
Mr. Ugarte,
tried.
you're gonna get reset, okay? Judge, where do I get the waiver?
Well,
Consent.
if we're in person, you're not gonna need it
Okay, so in person Tuesday.
Tuesday.
Yes, ma'am.
Okay. All righty.
Yes, ma'am.
Yeah.
Okay, thank you.
Okay. Thank you very much. Thank you, Mr. Ugarte. Sorry, you all waited.
Yes, ma'am.
Yes. Okay. So, Ms. Ruiz, Annex, thank you very much.
Thank you, Your Honor.
Have a good day.
You too.
All right. Downtown, if you'll start your camera, please. Thank you. All right. Calling cause numbers 2022-0D04904 and 2022-0D01523, State of Texas versus Eileen Mariah Ruiz. May I have announcements, please?
8-1 area for the state of Texas, present ready, Your Honor.
Rick Huffman on behalf of Miss Ruiz. We're ready.
And Ms. Ruiz is appearing remotely from the downtown jail. We are scheduled for 2 pre-rebos. Let me pull up the case summary. How long has she been in custody? Almost 2 months.
38 days, Your Honor, is what I show.
Probably feels like 2 months though, Judge.
Today feels like 2 months. What are you talking about?
Uh,
Were we at a number?
Well, Judge, we were hoping the court would consider the Inspira court. This case, it's a substance abuse issue case. She's on probation, Judge. She self-admitted to using. She had another slip, Judge, but I think the Inspire court would do her some good as well as do the community some good. Her kids too.
This is Jacob's case, and what I'm seeing is 7 TDC on a plea of true. 24 months.
I'm here.
Okay, there he is. Good.
Hi, Mr. Reynolds.
Hi, Judge. How are you?
All right. So we're on Eileen Ruiz.
Yes, ma'am.
I have her on some probation cases. Miss Waneri was letting us know you're wrecking 7 TDC.
Yeah, is Mr. Huffman here?
He sure is.
Okay.
Do I have anything coming up? I'm seeing some misdemeanor. Oh no, those are already pled to. Okay.
I think we're just waiting on the cases in this court. I don't think there's anything else left outstanding.
You mean not something new, right? Just her probation cases?
Right, just probation cases.
Okay, well, they want 7 TDC, Mr. Huffman.
I haven't spoken to Mr. Reynolds about it. I think I ought to give him a call and give him some background about Miss Ruiz. She's just a nice young lady with, unfortunately, some mental health issues and some substance abuse issues.
Okay, well, you know where to find me.
Let me look at the settings. Okay, I for some reason I thought she had a new case, but she does not. We had a probation status on July 23rd.
So Judge, there were some misdemeanor arrests
Mm-hmm.
a few months ago. The Mr. Teigman in that court dismissed those cases with a plea to her old misdemeanor cases before she got put on probation. That worked for us, and then this court, I think it was Judge Larson, gave her a PR bond in this case, and she was out. She had reported a couple times. And then I think there were some emails to the probation department. Well, the problem, Judge, she self-admitted she was using, but she was straightforward with the probation department, and I guess that's why we're here.
Does she have any pen trips?
She does.
How much time did she do?
I think 2, Judge.
Well, I mean, if y'all need to talk, that's fine, but I'm not gonna bring her back for 30 days. She'll come back in 30 days.
Should I get her screened? I mean, I know that's not binding on the court, but maybe just to leave that option open for the court. I'm talking about the Inspira court.
I'm not suggesting it. Do whatever you think you need to do, Mr. Huffman.
Will do.
Okay. All right. See you in 30 days.
Thank you, Judge.
Have a good day.
May I be
Downtown. Thank you.
Thank you, ma'am.
Yes, Mr. Huffman.
Thank
Did you get your jury sheets? Why are you laughing?
I'm not, Judge.
Erica, you saw him laugh. You heard him laugh, right? She typed it up. She said she said Mr. Huffman laughed at the suggestion of going to jury trial. That's what she put.
I'm working on a strongly worded email to Miss Winery.
Oh, wrong approach. Wrong approach. Rick. Is everything good? Can we all go our respective ways? All right. Have a good day and thank you.
You too.
Have a good evening, everybody.
Bye. See you guys on Thursday.
See you Thursday. Well, we'll see. We'll be in trial or picking the jury.
Oh, I plan to come watch some of that. So I'll see you guys Thursday.
That's your idea of fun, Miss Winery?
It is.